Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Mr. McCurr is back, and he's about to learn exactly why having legal representation is so important. If this is your first time watching one of my videos, this is actually part 2 of a case we covered a little while ago. Daniel McCurr is back in court, and once again, he refuses to cooperate with Judge Simpson or answer even basic questions. He carries himself with this extremely smug attitude, acting like he's somehow above the process and everyone involved. As you can already tell, things get off to a rough start for Mr. McCurr right from the beginning. He's already making a bad impression, and honestly, his behavior just keeps getting worse from there. At one point, he's literally chewing gum in the courtroom while representing himself, which is definitely not helping his situation at all. This is exactly why having proper legal representation matters. Trying to navigate court on your own ease while being disrespectful and uncooperative is usually a recipe for disaster. So please, don't follow Mr. McCurr's example here. Anyway, enough talking from me. Let's jump right in and see what kind of chaos unfolds between Mr. McCurr and Judge Simpson in today's hearing.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a prelim.
You wish to have a preliminary examination?
Preliminary examination, yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as to whether or not discovery is complete, the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So It was improper for the wording, Your Honor. I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying. Because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We could try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This guy is honestly a perfect example of why legal representation matters so much. Not only is he choosing to represent himself, but he also carries himself with this incredibly smug attitude, as if he's somehow going to outsmart the judge, which is obviously not a great strategy. I honestly don't know what made him think that approach would work in court. If you guys have any thoughts on why he acts this way, let me know in the comments. To me, he gives off a very similar vibe to the sovereign citizens I've covered on this channel before. There's always that same overconfident, confrontational attitude toward the judge. Almost like they believe they're above the process or somehow smarter than everyone in the courtroom. It's honestly hard to watch. And this isn't even a minor case. He's dealing with serious allegations involving assaulting a police officer, which is already a major issue on its own. On top of that, it was mentioned that he also lost custody of his child in connection with everything surrounding the case. Situations like that are obviously extremely serious and not something to be taken lightly. But despite all of that, he walks into court acting like none of it matters, as if it's just another ordinary day, and all he has to do is casually deny everything. Realistically, this is exactly the kind of situation where having an attorney is incredibly important. Instead, his behavior only seems to make things worse and creates an even more negative impression in front of the judge. This is why self-representation can go so badly, especially when someone clearly isn't taking the process seriously. Time and time again, these courtroom clips show people hurting their own cases far more than helping them. Anyway, that's my take on this hearing. I'll be covering the next court appearance once it comes out, which honestly should be pretty interesting based on how this one went. If you enjoyed this breakdown, I'd appreciate a like and subscribe. It really helps support the channel. Thanks so much for watching, and as always, take care.